Good afternoon, everyone. I'd like to welcome you to this week's webinar presentation. My name is Kathy Purdy. I'm the Marketing Manager at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will address those as time allows. If you would take a moment once the webinar has ended to complete the brief survey, we would appreciate that. We do share your comments and suggestions with our presenters so they have ideas for future topics. So to start our program today, I'm going to hand it over to Andy Bobrek.
Thank you, Kathy. Appreciate that. Great to be with you again, everyone, this week. We have another excellent panel of bond attorneys who are going to present on some of the emerging topics, both COVID related and not COVID related. I also wanted to say thank you for the suggestions that folks did submit last week for topics to discuss. I'd encourage you to keep those coming. Please insert those in the Q&A section. Just say suggested topic, put a colon, and let rip on what you'd like to hear us talk about. We'll take that under consideration. Obviously, we want to be responsive and provide you with timely and helpful information. So without further ado, I want to introduce one of my good friends and colleagues here at the firm, Suzanne Messer. Suzanne is a litigator, an all-star, and again, somebody I'm really excited to have here with us today. Suzanne's going to talk about some of the things that she's seeing in the course of her practice, her litigation practice, both COVID-related and non-COVID related. I think for all of us, these are helpful things that we can keep top of mind as we continue to navigate these uncertain and ever-changing times. Suzanne, take it away. Thanks.
Thanks, Andy. So it's great to be with everybody. I thought I'd start off by giving everybody an update as to how the courts are operating at this point in time as we hopefully start to emerge from the pandemic, as vaccines have become more available and those numbers are increasing and capacity is allowed to sort of increase in all of our places of business. So last week, Chief Judge Janet DeFiore of the Court of Appeals announced that all staff and judges will be back in the state courthouses for in-person proceedings as of May 24th, so only a month from now. And this will be the first time that our state courthouses are fully staffed in person since the pandemic began in March of 2020. So that's a development that hopefully will start to spur along some litigation that's been just sitting around and waiting for jury trials to start again and for in-person proceedings to start again. So jury trials have already started to resume, of course, on a limited basis, but with the increased staffing, we're going to see more of those continue to go to trial. There's going to be safety measures in place for jurors and court personnel and practitioners and witnesses, similar to what I'm sure we're all seeing in our in every other place that we travel to these days. So there's going to be COVID screenings for jurors in some cases, temperature checks, masks, social distancing. And the social distancing is what's going to sort of impact how fast our cases continue to move along, even after we have all of this staffing back in place. Because the jury trials that can proceed have to proceed in larger courtrooms, which don't frankly exist in some of the smaller courthouses throughout our state, in the more rural areas, for example. So we're still going to see some delays in those cases. We're going to see jury trials in criminal proceedings obviously take precedence because of constitutional requirements of speedy trials for criminal defendants, but we're going to start to see our civil cases also, kind of come back alive. So I suppose depending on what side of those cases you're on, that's either good or bad news, but we are going to see it start to open up again. That's our state courts. Our federal courts also been opening pursuant to state guidelines and CDC guidelines. We have seen in most of our district courts in New York, there had been repeated postponements of in-person proceedings and jury trials. Those timelines are expiring and not being renewed. So it's going to be the same type of thing. We're going to see jury trials start up again. Criminal defendants there will also take precedence, but we're going to see our civil jury trials in-person proceedings increase as well. So that's sort of how the courts are functioning these days. Also, the courts have and practitioners have sort of begun to master different virtual and remote type of litigation. So we've been regularly conducting depositions just like this over the screens. We've been appearing at bench trials and motion arguments virtually and remotely in different formats using Teams and Zoom and WebEx and things. So it'll be interesting to see for us how those types of virtual processes and procedures continue even after we kind of enter into our new normal. That will obviously affect the way we litigate cases, and it'll affect obviously the costs of those cases to our clients. So it's something that we'll have to determine what that new normal is as we go along. So as these courthouses are opening and things are starting to move along again, what types of cases are we seeing? And I am going to focus mostly on COVID-related cases to kind of stay on topic. Obviously, with litigation, there's a lag. So there's a COVID-related regulation or issue that that pops up that is dealt with, for example, by an employer. And then we see the litigation come afterwards, right? So we're starting to see COVID litigation over insurance coverage. So obviously everybody who has had business disruption because of businesses not being able to operate are fighting for coverage under their commercial liability policies. Those decisions are starting to come out. So there's a couple of decisions out of the federal courts downstate in New York City. And there was a recent decision out of the commercial division in Nassau County. That involved a movie theater that was, obviously forced to shut down, and I think is still shut down. And they sought coverage under their commercial policy for business interruption because of loss of use of their physical facilities. What this line of cases, what this case said, relying on other cases that have already come out, is that typically under commercial policies for loss of use of space, what's being referred to and what's being covered there are loss of use because of physical damage to a facility. And that's not what we have here. So it appears that the trends, at least in New York State, are that these commercial liability coverages are not going to be compelled to reimburse for business losses due to the government shutdown mandates. Of course, every policy is different. And if you are looking at your commercial policy or any other business related policy that you have, please give us a call your favorite bond attorney. We can look at the policies. We know what sections to go to, and we can advise you based on your own policy. But those are starting, we're going to see more of those in the next year or so. Another interesting case that's pending right now was a case brought by the New York Attorney General against Amazon. And this case was commenced in state court in February, and it came out of an investigation of the AG's office that actually began in March of 2020. When everything began to shut down. And there were a couple of employees that complained about the way Amazon was handling their workplace safety, not properly contract tracing, not properly disinfecting and cleaning facilities. And the Attorney General found that, in fact, the guidance wasn't being followed, the mandates weren't being followed with respect to contract tracing. The AG also found that 2 employees who had complained about these issues one was terminated and one was disciplined in another way with a final warning. And so the lawsuit that's now pending, deals with both of those issues. So essentially what is happening is that the Attorney General is saying that these employees were whistleblowers. They have protection under the New York labor law. And so we'll see how that litigation proceeds. It's been pending since February, but there's been a lot of procedural ups and downs. So no substantive issues or decisions have been issued, but it will be interesting to see how that case develops. I expect we're going to see more similar whistleblower type cases under the New York labor law also in the upcoming year or so as we proceed through whatever the new normal is in everybody's places of business. And I suppose the last topic I wanted to touch upon today is some litigation in higher ed. which is near and dear to my heart and what I spend most of my days doing these days. So any of our higher ed clients who are listening to this are painfully aware of class action lawsuits pending throughout New York State. There's approximately 20 of these, and they're all across the country. The theories are that students who were not able to remain on campuses in March of 2020, when Governor Cuomo and other states shut down in-person operations and then transitioned to a remote type of instruction, those students didn't receive the benefit of the bargain or the bang for their tuition buck, and have brought tuition class action cases seeking refunds of tuitions, student fees, and in some cases, housing and meal plan charges. So those cases in New York are proceeding. Unfortunately, we've had only varying success in getting rid of those cases at the pleading stage. Some have been dismissed, some have been dismissed for certain charges, and many are continuing on into our discovery phase. So we will get another opportunity to talk about what all of these wonderful institutions did to service the students and provide students with activities and instruction and a valuable experience in that sort of time frame during which they weren't able to be in person as everybody would have loved to have been. So that's a huge portion of what we're doing here at Bond, and we are monitoring that line of cases very carefully. I also expect to see, as colleges and universities start to come out with vaccine mandates, my guess is there will probably be some challenges to those, whether they'll be large scale or sort of on an individualized basis of somebody who is asking for an accommodation or an exemption. We don't know yet. Again, these announcements have just started coming out from our New York colleges and universities that vaccines are going to be mandated for many students to return to campus. So we're going to keep an eye on that. And then actually, I know that Laura Hershberger is going to be talking about vaccines specifically in the next segment. So it's actually, Andy, a really good time to transition to Laura.
That was smooth. You're doing my work for me, Suzanne. There, thank you.
No problem.
Before we transition, one question. I think our clients will be interested in that Amazon case. I think it's one to watch. And as you know, the state certainly put out a tremendous amount of industry-specific guidance, and our clients have been following that guidance closely and appropriately consulting with counsel as needed along the way. But inevitably, there are some gaps, and it'll be interesting to see. One of the litigation questions we got quite frequently, I think, focused on concern about transmission and a third party getting sick due to exposure at a workplace or a business. And is it fair to say that we haven't seen that much by way of litigation developments in that area?
No, we haven't. So some states, as I know, that you and I have discussed, have liability shields in place, legislative liability shields. New York is not one of those states. But we have not seen, outside of this Amazon case, which does deal with contact tracing and exposure amongst employees, we haven't seen yet a lot of litigation over, for example, you go to a restaurant and perhaps we're exposed at the restaurant. There is no legislative liability shield in New York State at this time, but we have not seen a rash of that type of litigation at this point.
Yep. Good. Thank you. That's good news. And I think, great, the message is continue to be steadfast in your adherence to the guidance that's out there, and when in doubt, seek advice and so you can make an informed decision. So Suzanne, thank you for being with us. I hope you'll come back again one of these weeks and maybe give us an update on the Amazon case. So thanks.
All right. Thanks, Andy.
Yep, my pleasure. All right. Next up, we have Laura Hershberger. Laura's a partner of mine in our labor department here in Syracuse. We work very closely with one another on a wide variety of issues. Laura's also a leader of our firm. It's great to have you with us here, Laura, today. I know you wanted to talk a little bit about vaccination issues, something we continue to get a lot of questions on from our clients.
Thanks, Andy, and thanks, Suzanne. Wanted to give an update to everyone on kind of where we stand with respect to vaccinations, and in particular mandated vaccinations. This is top of mind for many business leaders, whether or not to mandate vaccines for employees or across the organization. I'm sure you've heard us speak at length before on this topic, and the general feeling is that the winds tend to be blowing, as a general rule, in the direction that says that an employer, a private employer, would be able to mandate vaccination. We gleaned that from the EEOC guidance that was released many months ago, where the EEOC did not pose to itself, in terms of a fact, a question to answer. It didn't pose the question, may an employer mandate vaccines? It instead started its guidance rather assuming that an employer could mandate vaccines. So when it answered questions, its own questions about vaccination, it said if an employer were to mandate vaccines when they are available, then what would need to be done in terms of disability accommodation and that sort of thing. So the conversation, as the EEOC had set this up, is set up as though, again, there's kind of this background assumption anyway, an unspoken assumption that mandating vaccine would be lawful. We've been noting along the way, though, that that's the EEOC, right? And that is not necessarily the final authority on this. The final authority on this will be the courts, will be the judiciary. And eventually there will be challenges to employers and other organizations that mandate a vaccine. Those lawsuits are beginning. So we saw the first filed in February out in New Mexico. An employee, this was a Department of Corrections employee, the Department of Corrections had mandated that all staff be vaccinated, and a particular officer filed for an injunction attempting to stop his employer from requiring that he be vaccinated. The resolution of that case, frankly, never reached the true merits of the case. There are two stages of an injunction proceeding. In this first phase, the court found that the employee had not stated the sufficient kind of immediate harm. He hadn't alleged that he was going to be terminated if he didn't take this vaccine. And so the court did not issue the TRO in that case. And the plaintiff, the officer, ended up withdrawing that immediate request for an injunction. So we never really kind of saw the court get into the depths of the merits there. But that case was followed on the heels by another case that has been filed out in Los Angeles, California. That case has been filed by 7 school district employees. The Los Angeles School District has mandated that all its staff be vaccinated. And as I say, 7 of those employees have filed suit attempting to obtain the same relief, an injunction stating that the employer is not permitted to require them to have the vaccine. And the objections are really based on the fact that these vaccinations have been distributed and made available through the emergency use authorization procedures and not typical FDA approval procedures. The plaintiffs are claiming in those cases that, in essence, the vaccine health risks are too great, or too unknown at a minimum, to make mandated vaccine permissible. That case has not made its way very far. I think I saw on the docket that there's been a briefing schedule set up by the court, and so we'll be keeping that case on our radar screen. These are the first of what very likely will be several more cases, as Suzanne signaled, as large institutions like colleges and universities kind of move in this direction. School districts, hospitals, we may see more and more challenges. And that's where we will ultimately get the final answer in terms of the big question, may we mandate, and if so, under what circumstances? For employers right now trying to make decisions and trying to weed your way through where this stands, what I have seen from all surveys is that no more than 10% seems to tap out around there of employers around the country are either have mandated vaccine. We saw a large law firm in New York City take that route, or are considering mandating vaccines, more likely than not, the other 90% are going in the direction of trying to encourage employees to have vaccines, but without making it mandatory. But again, that's very shifting sands. And as this develops, as our COVID strains and variants take hold or not, right, all of this landscape is going to change, and employers may be thinking about that differently. For the immediate term, if you are an employer that is inclined to mandate vaccines, please bear in mind that you do need to make exceptions for medical reasons and or for, which would include pregnancy, as well as for religious objections. And a religious objection would be a sincerely held religious belief by that person, by that individual, not necessarily a tenet of a major religion, not necessarily something that a leader within a religion says is a basic belief of that religion. It could be something very personal to the individual. It has to be more than just a person's preference. It has to be more than just the person is skeptical about vaccine or personally isn't sure yet that the health benefits are there. That person wouldn't fit within a religious objection, but any sincerely held religious belief does. And of course, medical conditions that are contraindicated for vaccine. What would employer do in those situations? The exception is really going to depend in terms of what an employer practically does in response to either a religious or medical objection. Will depend on many factors, and it's going to depend on what the employer's business is, what the risks are of having a non-vaccinated individual in that role. Is the person interacting extensively with other people? Is there a way to limit that in any way? Are there other measures that could be taken that would be a reasonable accommodation sufficient to ensure safety? Continued masking and continued social distancing, or could the person work from home, right? All of these things would have to be considered. If an employer is going to mandate vaccination, then we would have to engage in a reasonable accommodation analysis. What are the risks of having a person who's non-vaccinated in the workplace doing work? Also recall that if you have a unionized workplace, you very well may have a bargaining obligation prior to implementing a mandatory vaccination rule. It may be possible that in your particular collective bargaining agreement, there is sufficient language in that agreement to constitute a waiver. But that is something you'll really want to think carefully about and consult with an attorney about whether or not you have a bargaining obligation based on your exact set of facts and circumstances. And we're going to keep our eye on this issue because it's clearly not going away. It's going to develop. It's going to be influenced by the courts now. At this point, we're going to see it moving into that realm. And then we're going to have a better sense once some of these cases move their way through to have a final answer here, a final answer in our Who Wants to Be a Millionaire about whether or not we can mandate vaccines.
Laura, thanks a lot. I hope I didn't, if I missed this, I apologize. But one question we got quite a few times from attendees was whether or not they could require an employee to answer whether or not they've been vaccinated and if they could require submission of documentation of the vaccination.
Great question, Andy. Yes, and we have been fielding questions about asking employees about their vaccinated status quite frequently. The answer is that we can. The EEOC has said that asking whether or not a person is vaccinated is not a request for medical information. And consequently, we don't have to kind of do this balancing test to see if there's a sufficient business necessity there to justify the question. So yes, we can ask the question, and we can even require proof of vaccination if you are an employer who has decided to mandate the vaccine. Now that said, here's the tricky part. Yes, no. Have you been vaccinated? Yes, no. That's going to be a permissible question. What you don't necessarily want to get into, where we would have to have more justification for asking follow-up questions. Why haven't you been vaccinated? That's a question that shouldn't be asked. Now, that is a question that may elicit disability-related information. It may elicit medical information, and it may elicit religious information. Now, again, if you have made the decision as an organization that you're going to be mandating vaccines, then you're going to be engaged in that kind of conversation with employees, and you're going to do it on all the right ways. But if you're not mandating vaccines, you're simply asking the state of your employees' vaccinated status, the answer is yes, you can ask the question, but it does need to be carefully framed. And you really should have that looked at by an attorney before sending it out to employees.
Laura, thanks a lot. Great advice. And I think otherwise you really covered the other questions that we had in there. So thanks for joining us. I'm sure there'll be more to report on this vaccination issue, and I hope you'll come back.
You bet, Andy. Have a good day, everybody.
All right, thanks. All right, next up is Paul Bueller. Paul presented last week, for those of you who may recall, and talked about various UI issues. Among other things for us, Paul's been tracking these issues very closely, communicating with state officials on a fairly regular basis, and is a great source of information on these things. After and during last week's presentation, where Paul covered a few things, including the rampant fraud that I know so many on this call have experienced with false claims or personal identifying information being misused, or there being identity theft associated with claims, and there being these fraudulent claims, as well as the action that the state had taken amidst COVID and information that it had disseminated, making clear that employers would not see an adjustment in their experience rating, in other words, their tax rate that governs if they pay on a quarterly basis, or alternatively, if they use the benefit reimbursement model, that they wouldn't see an increase in charges resulting from all the COVID-related claims. And that guidance is still out there to my knowledge. Even so, we're hearing anecdotally that clients are receiving notices of charges and that there are increased rates on there from what their experience rating had been before. So based on those questions, we wanted to have Paul come back and address that issue a little bit and give you a little bit more background on what we're seeing and what he's seeing. Paul, thanks.
Thanks, Andy. So I actually got some new insight on this as recently as Friday. So I basically was part of a business council webinar related to unemployment insurance charges. And so let me just kind of set the stage for you a little bit here. So as Andy mentioned, back in January, the Department of Labor issued an order basically saying we're going to cancel all the unemployment insurance benefit charges that are charged against individual employers. We're going to remove them from your account. We're going to charge them to the general account, and New York State will be paying for them effectively. They did this retroactively, dating back all the way to March 9th of 2020. At the time, this sounded like great news. You know, we're not going to experience any increases in our experience rating, and the hope was that would mean that UI taxes would remain flat and that self-insured employers would not be paying anything moving forward. That doesn't seem to be the case here. So basically what's happened is New York State has moved all of those charges, like I said, from employer accounts to the general account. The problem that they're having now is that they are $10 billion in the hole. Basically, they have paid out roughly $12 billion more in unemployment benefits than they had in cash lying around. Before the pandemic, they had basically a surplus of about $2 billion. And now with all of the claims, they said, actually at this business council webinar, they said that in the last 12 months, they have paid out 38 times what they normally pay out in a normal year. Like I said, and this is what has caused this $10 billion deficit. So New York State has to get that money from somewhere. And like I said, they've committed to the fact that your experience rating will not increase. So what they did instead was they basically took this $10 billion deficit and they are spreading it out across all employers that participate in the normal unemployment system. So your experience rating did not change, but because experience rating is only a portion of the calculation that they use to determine what your taxes are. What they've done is, like I said, they've taken this $10 billion deficit, spread it out across all employers in New York State that participate in the system, and everybody's tax rate went up, even though your experience rating stayed the same. So for 2019 and 2020, a really, really good employer that had very little employee turnover, very few UI claims, could have achieved an unemployment tax rate of 0.6%. That's what they were using over the last several years for, like I said, those really good employers that didn't have a lot of employee turnover. They had to increase that very significantly this year. Now the lowest rate that those employers can achieve is 2.1% for their UI tax bill, and it goes all the way up to 9.9. So effectively what this means is that everybody is paying a lot more money in unemployment insurance taxes, even though their experience rating did not change at all, because I think DOL was a little overwhelmed. They couldn't attribute claims to employers quickly enough and kind of understand where are these claims coming from, how are we handling them in terms of contesting this. And so they just said, this is all the money that we have to pay out to all these people who are receiving unemployment benefits, and let's just spread this out amongst everybody. So, unfortunately, it's not great for any of us. But what I would recommend for you guys kind of moving forward is if you think there's an error in your unemployment insurance taxes, pay them now anyway, and then reach out to DOL. If, like I said, if there is an error, if there is a mistake, to sort it out. The problem is that technically, if the tax is assessed against you and you don't pay it, by not paying it, that is a misdemeanor, punishable by a small fine, but it also implicates your corporate officers. They can also be personally charged with a misdemeanor and personally fined. And this is, your CEO, your president, your treasurer, your secretary, basically all the individuals that have some accounting power and decision-making authority in your business. So I realize this is not the best news. But like I said, if there is an error, you can have an opportunity to resolve that with the Department of Labor, but pay now and sort it out after the fact. The other thing I wanted to mention for you guys, I've gotten a ton of questions about this. All of you self-insured employers right now, because of this cancellation, I know you're still getting quarterly bills. You should not be paying them. We know that under the CARES Act, you're also entitled to a 50% reimbursement. It was actually increased to 75% under the American Rescue Plan. I've gotten a bunch of questions about when am I actually going to see that money? Because for most of 2020, you guys were paying 100%, knowing that down the line, you were going to get 50% back. The Unemployment Insurance Division has not figured out how to get you your money or when they're going to get you your money. We asked them very directly this exact question. Several higher ups from DOL were on this business council webinar on Friday, and they basically will not commit to an answer other than that the money is coming. Like I said, I think their issue is just that they don't have the cash lying around because they've had to pay out 38 years worth of unemployment benefits in 1 year. And so with this $10 billion deficit, they just don't know when and how they can get money to employers. But for you self-insured employers, at least you don't have to pay right now, even though, like I said, you're going to get your quarterly bill. But until the state of emergency ends or the Department of Labor affirmatively ends this cancellation, you should not have to pay anything moving forward. So that's what I've got, Andy.
No, thank you. And on that latter point, when you say you shouldn't have to pay anything now, you're referring to those who are participating in the benefit reimbursement model, correct?
Yes, all the self-insured employers that pay out of pocket a quarterly bill. Those are the employers, like I said, you're still going to get the monthly statements indicating who is on unemployment insurance. You're still going to get the quarterly bill, but no money is currently due. You won't have to pay anything in response to those bills until DOL cancels that order moving forward.
So on the program that you attended last week, where the state officials were, did they bring up this payment issue for those who aren't on the benefit reimbursement model, who get the quarterly statements and who are facing these increased charges? Did they indicate or kind of reference this misdemeanor liability or non-payment situation on that call?
They didn't, but they did mention that they obviously were encouraging everyone to pay and mentioned the fact that you can work out a payment plan if you reach out to DOL if you don't have the money right now. But they were not necessarily forthcoming with any relief in sight.
Yeah, just a thought. I know I've talked to a couple clients on this, and in some cases it's a pretty substantial increase that they're facing. 6 figures easily in some instances. So I think it could be worthwhile to at least get a second look at these issues too, and assess your options with respect to what type of contest you may be able to make over the charges, and just to get a full understanding of that, so that you as the employer go into this process with your eyes open. I think it's fair to say, Paul, there's still a number of questions as to the allocation of these charges, what a fair share is, and I think clients want to go in there making sure that they're preserving their rights in any defenses they may have. Fair to say?
Absolutely. The other thing that they specifically mentioned, and New York State, I'll be honest with you, I don't feel like they're really taking responsibility for what's happening here. They've kind of pushed the blame to the federal government. They say, well, we're waiting on money from them. They're the ones who are ultimately providing this relief, and they couldn't answer questions about what they were doing in terms of next steps to actually help employers here.
Yeah, that's my concern, is that it's a catastrophically large mess that's here, that's slowly percolating up. But great, we appreciate you monitoring it, Paul, and I'm sure we'll have more to report on this too. So thank you very much. All right, next up is Katie Anderson. Katie, good to see you as always. Just so you all know, Katie keeps all of us updated here at Bond on all things Albany, keeps us out of trouble. And so I know, because Katie's been telling me that there's developments in Albany and some notable things. And again, we're happy to have you here with us, Katie.
I'm always happy to be here. It's again, I need a routine in my life, and this is it. So looking at what's happening in New York right now, don't worry, I'm going to get to all of your questions about masks and what's happening with offices. Don't worry, we'll get there. Looking at new reported cases, we're seeing a good decrease occurring, a pretty steep drop off. This is related to likely the vaccines, the fact that New York has been very successful in vaccinating people. Looking at the numbers, 46% of New Yorkers have received their first shot. 32% are fully vaccinated. So what's interesting is I show you this chart every week, and we're looking at when are we going to hit these thresholds of 70%. So our current pace of vaccinations is currently slowing down. There's been a drop off since April 11th. In the number of people receiving vaccines. We have the supply, but the demand is not necessarily there. The demand, the people who really wanted to get the vaccine, everybody's likely has gotten their first shot. Now the question becomes, how do we make accessing the vaccine, one, easier for people who haven't been able to do it thus far? So walk-in clinics, for example, or in rural communities, how do we drive it out to you? Or in urban communities, how do we get it to housing developments? And that's really where the Johnson & Johnson slowdown slowed a lot of things down. So the other vaccines need to be refrigerated at a very precise, low temperature. The Johnson & Johnson vaccine, on the other hand, doesn't need that. On Friday, the CDC and the FDA said that the use of the Johnson & Johnson vaccine may resume immediately. The only change is that it comes with a warning for women specifically who are under the age of 50 of a rare but increased risk of blood clotting. This is a quote from the CDC's statement. Nearly all reports of this serious condition, which involves blood clots with low platelets, have been in adult women younger than 50 years old. So that is the only change with the Johnson & Johnson vaccine. Hopefully this means that we will start to see more clinics and movable places, people being able to drive out to people who need to receive the vaccine. Reopening updates. Here we go. The topic everybody wants to talk about. What's happening with offices? On May 15th, offices will be going to 75% capacity. Now, I'm going to skip down to my big remember at the bottom of this slide to say capacity is based on the maximum occupancy, not on the total number of employees. So if you are in a building that has a certificate of occupancy, which it likely does, it will say how many people can be in this space. You will be working off of 75% of that number. If you have multiple buildings to worry about, you have to worry about that for each building. The easiest rule of thumb to follow here is, can we keep people 6 feet apart safely? Are people working 6 feet apart, or are they closer? If, for example, your office layout does not allow for people to be 6 feet apart, then they have to be masked while they're working. You can put up the barriers, the plexiglass barriers, that is in the office reopening guidance, which I'm actually pulling up right now to read off of, because we got a question about this. So responsible parties, which would be you, may modify or reconfigure the use and or restrict the number of workstations, so that employees are 6 feet apart in all directions and are not sharing workspaces. When distancing is not feasible between workstations, responsible parties must cover and require the use of face coverings or physical barriers. So either you put in those physical barriers, which have to be put in place both in accordance with the fire code and with OSHA guidance, or the people have to wear their face coverings the entire time that they're sitting within 6 feet of each other. I saw a question about reopening questions, you know, the questionnaire that you have to send to employees every day before they come in. Yes, you still have to do that. Yes, you have to continue to do that if it's been, even if everybody's vaccinated. No, the questions haven't changed yet. Will they change? I don't know. They might just fall away altogether, but I'm not really sure what's happening there. I'm not sure many people have eyes on that in the health department right now. Turning to other reopening updates, gyms outside of New York City were at 50% capacity. Casinos, 50% capacity. And we also had the announcement for our Syracuse folks. This is great news. For me personally, this is great news because I love outdoor things. The state fair will be from August 20th to September 6th at 50% capacity. That is always, as always, all of these things are subject to change, but this is where we're heading in terms of capacity limits. There are a number of bills that are working their way through the legislature this week that need to be discussed. I could have taken the whole 45 minutes to talk about each one of these, so bear with me as I do it in 3 minutes. The New York HERO Act has not been signed yet. It was sent to the governor. It did pass the legislature last week. It was sent on April 23rd. A fun thing about New York is that when a bill is sent to the governor has 10 days to sign it or veto it. If the governor doesn't sign it within 10 days, then it automatically becomes law. Remember, the 10 days doesn't include Sundays. So he really has 11-ish, maybe 12. Safe staffing ratios. This is a bill that is working, it's two bills that's working its way through the legislature. There's a nursing home bill and there is a hospital related bill. This would require that 2/3 of the mandated 3.5 hours of care be provided by a certified nurse aide, and also 1 hour of care with a nurse. Evictions and foreclosures. Been getting a lot of questions on this lately. Right now, the eviction and foreclosure moratorium is set to expire on May 1st. There is a bill working its way through that is likely to pass that would extend the moratorium on evictions and foreclosures to August 31st. The foreclosures and evictions, if you are a commercial tenant, It applies to small businesses who would need to fill out hardship declaration forms. If you have questions on that, please get in touch with us. We've been helping lots of small businesses do this. The census, final slide. New York is losing 1 congressional seat this year. Everybody was really expecting that New York would lose 2 congressional seats, since New York has lost 2 congressional seats every year since 1950. But the really bad news here, the bummer news, is that New York would have kept that seat if only 89 more people had filled out the census. And as somebody who is a real voting nerd, that just makes me hurt. Redistricting. So this is all going to really be impacted. The congressional districts and even your state districts will all be deeply impacted by the census, but none of that's going to happen until they release the block data in August. So that will tell you the population on a very granular level. And it's a very nerdy thing, and I love doing it. So if you have questions on redistricting or want to just chat about that whenever, I'm always available.
Well, this is great. I didn't know that, Katie. I am also a big into redistricting, especially Perfect. Congressional. And so we can nerd out together on a Great. Topic. Great. Well, no, thanks for the update, Katie. I really appreciate it. Good to have you. We'll see you next week.
Always.
All right. Once again, thank you to everyone who presented today. Thank you to our audience. We appreciate having you here each week. The information on the topics, contact information is on the slide here. Just one note, our book, the book that Bond, Schoeneck and King wrote, New York Employment Law, The Essential Guide for and with the New York State Bar Association, has been restocked on Amazon, so you can get your copy. I'm told autographs are available if anybody would like an autographed copy. I'm kidding. No one wants that, of course. But in all seriousness, it's a great treatise, something good to have on your bookshelf. And if you have any trouble getting one, let us know. We can help. Thanks, everybody. Good luck this week. Take care, and we'll talk to you soon.